You're listening to the Patenting for Inventors podcast with registered patent attorney, Dr. Adam Diamond, founder of Diamond Patent Law, the #1 source for securing your intellectual property needs. Now, here's your host, Adam Diamond.
Hello and welcome to the Patenting for Inventors podcast, episode 61, 8 options for responding to a final office action. My name is Dr. Adam Diamond, a registered patent attorney and founder and owner of Diamond Patent Law in Los Angeles, California. I can be contacted through my website at diamondpatentlaw.com. That's DIAMENT, patentlaw.com. Or if that's too hard to remember, you can get to it through patentingforinventors.com. That's patentingforinventors.com, or call me at 424-281-0162. And while most attorneys can only practice in states where they're members of that state's bar, patent attorneys are actually allowed to practice patent law in any state. So feel free to contact me regardless of where you live. I've covered lots of different aspects of the patenting process, but so far I've mostly talked about when things go according to plan. I did talk about what to do when you get patent rejections and how to respond to them, and I also talked about allowances. But sometimes you respond to a rejection and you get another rejection for the same thing. Your arguments just didn't convince the patent examiner that your invention was patentable after you got your first rejection, and you get a second rejection. What do you do then? Your first response to the patent office wasn't convincing, so just making the same arguments again probably isn't going to advance your cause, but you'll still think that your invention should get a patent. This is where there's a lot of patent prosecution strategy comes in, because there are probably at least 8 things you can do, and I'm going to have individual episodes on most of these. This episode is going to be a very broad summary of these 8 options, and then I'll go into details of each of these later. Your second office action is usually called a final office action. Not always, but most of the time it's called a final office action. Technically, the patent examiner is supposed to give you a chance to respond to a rejection before sending a final office action. So let's say the examiner rejected your application based on one ground, and then you respond, and then the examiner decides to reject your application on entirely new grounds that weren't brought up in the first rejection at all. If that happens, technically, the second rejection isn't supposed to be a final rejection because it's the first time the examiner is bringing something up. Now, sometimes they're allowed to do it and call it a final rejection, but sometimes they're not. It does happen, and it's pretty rare that I get a final rejection and I fought the examiner and convinced the examiner that the final rejection shouldn't be considered final, but at least 95% of the time or more, the second rejection you get is probably going to be called the final rejection. Now, this term final doesn't mean that you're out of options. So final doesn't really mean final. It reminds me of that quote from The Princess Bride when Vizzini keeps saying inconceivable, but the things that he says that are inconceivable just keep happening. So Inigo Montoya says to him, "You keep using that word. I do not think it means what you think it means." That's what I think every time when I see the patent office sends out a final rejection. There's nothing final about a final rejection. It does not mean what you think it means. All that really means is that you just can't respond to a final rejection in the same way you respond to a first rejection. But even that's not entirely true, because some of the options you have essentially are pretty close to just responding to a first office action. But let's go through really briefly all the ways you can respond, and then in later episodes I'll cover some of these in more detail. These 8 things can be broken down into 4 groups. In the first group, we have abandonment. In the second group, we have responding to the examiner, which is going to be the same examiner that you've already had. In the third group, we are going to be responding by doing some type of continuation application. And in the fourth group, we have appealing to a panel of examiners or administrative judges that can overturn your examiner's rejection. Let's talk about the first group first, abandonment. I'll call this option 1. You just decide you're not going to fight for getting a patent anymore. There might be a lot of reasons for this. Maybe you are convinced by the examiner's rejection that you don't deserve a patent. Maybe you just don't have the funds anymore to respond. On the final rejection, you'll get a response date, which is generally 3 months or 6 months with extension fees. And if you don't respond by then, your application goes abandoned. You technically can revive it later, which I'll have a separate episode about patent revivals. But for now, your patent goes abandoned if you just don't respond. Then we got our second group of options, which are responding in some way to the same examiner that you've already had. And here there are 4 variations of it. I'll call these options 2, 3, 4, and 5. So option 2 is filing a response within 2 months of the rejection. Now, remember I said that you have 3 months to respond or 6 months with extension fees to do some kind of response to the patent office. But the patent office will give special consideration if you actually file a response within 2 months of your office action. I'm not going to go into great details right now, but this is best if you have minimal arguments or you think the rejection the examiner made is really minor and you can overcome it with just a simple response. If you file within 2 months, You don't have to pay any extra fees, and you will get something called an advisory action. Maybe the examiner allowed some of your claims but rejected others, and all you're doing is just amending the claims to a way you know the examiner will allow. One advantage for you if you file within the 2-month period is that calculating certain deadlines are changed if you file within the 2-month period, which gives you a little bit more leeway later on if you have to make other amendments. There's no fee for this kind of response. Option 3 is like option 2, but you don't make the 2-month cutoff. And I'll just call this response to final office action. You can just respond to the examiner, but I'd really only recommend this if the amendments are so minor that it will lead to an allowance because the deadlines don't change. If the examiner doesn't get back to you about an allowance, or doesn't even get back to you about why he or she is still rejecting it, and 6 months passes, your application goes abandoned, even though you responded to the final office action. There's also no fee for this. Option 4 is another kind of response called an after final consideration pilot 2.0. It's a lot of words just for another type of response. This is a pilot program that may not be in existence in the future, but for now, you can get another bite of the apple without paying any fee. The Patent Office encourages interviews between the patent examiner and the applicant. So if you go this route, you have to do three things. You have to respond to the office action. You have to narrow your claims, meaning you can't just argue for patentability of what you already claimed was your invention. You have to actually amend the claims and narrow what you're saying your invention is. And you're also agreeing to an examiner interview if the examiner wants an interview. This is a good option for most people because it doesn't cost any more in filing fees. There are a couple caveats. If the examiner feels like your response will take more than 3 hours of research, then the examiner can just give another rejection saying that it would take too long to do this research. Whether or not you've narrowed your claims are patentable. The examiner could allow your invention or might give another rejection in what's called also an advisory action. Option 5 is the last kind of response to the same examiner, and it's called a request for continued examination, or RCE for short. In this option, you're basically just paying the Patent Office to keep going. There aren't really any restrictions on this. You can amend the claims. You don't have to amend the claims. You can make new arguments. You can write new claims. You can cancel old claims. Basically, it's just like you're responding to a first office action, but you're paying money. Your initial application fees cover the filing, search, examination, and review by the patent examiner, your response, and a second review by the examiner. But if you want to keep going with more and more reviews, that's fine. You just have to pay money. Currently, there's no limit on the number of RCEs you can file. So if you file an RCE, generally right after that, you either get an allowance from the examiner or another rejection, and it's usually a non-final office action. Then you can respond to the non-final office action any way that you want, and then you might get another final office action. You might have to make the same choices again, how you want to go forward. There are fees for requests for continued examination, and I'll go over these in the specific episode about requests for continued examination. So those are the options for responding to the same examiner. Now, in the third group of types of responses, isn't really a response, but a new application. Instead of responding to the examiner, you can file a continuing application. I'll call this option 6. I talked about continuing applications in the last few episodes, so I'm not going to repeat them, but there are different types. So what you do is you let the first application go abandoned, but before it goes abandoned, you file a new application claiming priority to the original application, and you don't need to do any kind of remarks or arguments. You just file a new application, and there are lots of reasons you might want to do this. You might get a different patent examiner, but usually not. Maybe you want a different part of your invention examined, so you file a divisional application. There could be lots of reasons, but basically this option involves abandonment plus a new application before abandonment happens. In the fourth group of types of responses, it has to do with appealing your rejection. Now, what an appeal does is that it takes the decision away from the examiner and sends it to a board of examiners. Now, you might want to do this if you feel that the examiner is being unreasonable or just wrong on the law, and you know you're just not going to get the examiner to change his or her mind. I'll have a lot of episodes about appeals. There are really two things you can do at this beginning stage. For both of these options, you have to file something called a notice of appeal. This is just notifying the Patent Office that you're going to be filing an appeal, and the appeal goes to what's called the Patent Trial and Appeal Board, called PTAB for short. From there, you have two options. The first I'm going to call option 7 because talking about the total number of options that you have for responding to final office actions. After the notice of appeal, some things can happen, but eventually you'll file an appeal brief. In the appeal brief, you say why the examiner is wrong. It's usually more in-depth than just a regular response, and oftentimes it's more heavily focused on the law, because when you appeal, you're appealing to a panel of 3 administrative judges, not patent examiners, though I'm sure most of them at some point used to be patent examiners. The numbers change, but currently if you appeal to PTAB, it takes about a year to a year and a half for them to get to your application. So it's a long wait. It used to be about 2.5 years, so they've gone through a lot of the backlog, but there's still a long wait. Now, when you appeal to the panel of 3 judges, it's like a mini trial, and the examiner is like opposing counsel saying why you shouldn't get a patent, and you're on the other side saying why you should get a patent. The panel will make its decision, but even if they say that your invention isn't patentable, it's still not the end of the world. You can always file a request for a continued examination. You could appeal to a court above PTAB called the Federal Circuit, or you can file a new application that claims priority to your old application. The second option in the appeal route is called filing a pre-appeal brief. It's a maximum of 5 pages. These actually don't usually lead to an allowance most of the time, but sometimes it could be useful if you really think the issue is so cut and dry and the examiner is clearly wrong on some fact or law. They're much quicker and cheaper than a full appeal brief. When you do a pre-appeal brief and request for a pre-appeal conference, you have a panel of 3 examiners, and one of the examiners is going to be the examiner that you already have. And then you have 2 other examiners, usually your examiner's supervisor and someone else. So you already probably have at least one ding against you because your examiner has already rejected your application. And there's a good chance that your examiner has already talked to his or her supervisor about your application. So that's kind of 2 dings against you. And there are only 3 total. So that's why often it does not lead to anything that gets you to an allowance right away. As I said, your arguments can't have more than 5 pages. You're supposed to get an answer within 45 days. So this is pretty quick in patent time. So sometimes it's worth it because the attorney time that it takes to write 5 pages isn't going to be as much, and there's a quick turnaround time. And it's something that maybe you should consider, even if you're not likely to get an outcome that you like. And if you don't get the outcome you like, you then go on to the next step, and you go to the option I talked about last time, which is filing the full appeal brief. There are all kinds of variations of strategies where you can do more than one of these things at the same time, but that gets kind of complicated, and you should discuss it with your attorney on the best route to go. As a general rule, and this is really a general rule and not hard and fast at all, but since the appeal process can take a long time, if you have no other information, generally after a final office action, I would file an after final consideration pilot 2.0 request. If you still get a rejection, file 1 request for continued examination, and after 2 or more bites of the apple, with your request for continued examination and you're still getting a rejection and you don't want to abandon it, then it's probably time to appeal. If you know that your examiner often gets reversed on appeal a lot, then you might want to appeal earlier, but it does depend a lot on other factors. But as an order of priority, generally I would say 1, after filing the final consideration pilot 2.0 program request. Then 2nd, I would do the request for continuing examination. And then 3rd, I would appeal. That's a basic overview of your options when you get a final office action. I'll have specific episodes on some of these. I'm not going to have an episode just on abandonments or filing continuing applications because abandonment's just abandonment, and I've already discussed continuing applications. But for some of these others, I'll have specific episodes. If you want help with your patent application, you can contact me through my website at patentingforinventors.com. That's patentingforinventors.com, or call Diamond Patent Law at 424-281-0162. I'm Adam Diamond, and until next time, keep on inventing.
Thanks for listening to the Patenting for Inventors podcast with host Adam Diamond. If you enjoyed the show, please rate and review on iTunes. The contents of this podcast are intended for general informational purposes only. The facts of every legal matter are unique, and the content of this podcast should not be construed as offering legal advice for your specific legal situation. For more information and help with your own intellectual property needs, contact Adam Diamond at patentingforinventors.com. That's patentingforinventors.com, or call Diamond Patent Law at 424-281-0162. The preceding information may be considered an attorney advertisement and does not establish any attorney-client relationship.